Everybody say, say, how can I express my gratitude for all the many things you've done for me? Words are not enough to say thank you. So Lord, you are my everything. You're my everything. How can I express my gratitude? How can I express my gratitude for all the many things, you've Father, you done for me, yeah. Words are not enough to say thank you. So Lord, you are, you're my everything. See, I call you Jireh. You're my provider. I call you Eunice. You are my battle. I call you Rapha. Hey. You are my healer. Say, Lord, you are. You're my everything. I call you Jireh. You're my provider. I call you Eunice. You are my battle. I call you Rapha. You are my healer. Say, Lord, you are. You're my everything.
Hello and lovely good afternoon to you. Another Saturday is here with us, and we're live on BWTV for the community and the law. Now, the topic this afternoon excites me so very much. Applying for British citizenship. What time do you have to apply? How do you do that? Now, today we're going to look at the good, the bad, and the ugly part of that application. The senior partner of BWF Solicitors, Uncle Ben, lawyer Bernard Owusu, is our guest and resource person. Ladies and gentlemen, once again, welcome to the community and the law, brought to you by BWF Solicitors.
Our private client services team is recognized for providing clear and practical legal advice to our clients in the United Kingdom and Ghana. Expert help with will writing, probate or estate administration. Our will writers and probate lawyers can act for you to obtain grant of probate and carry out estate administration on your behalf. The probate takes place after someone dies. If there's a will, the named executor is responsible for ensuring that the estate of the deceased is secured, assessing its value and paying any inheritance tax. If there is no will, the interstate and inheritance rules require similar responsibilities. Our lawyers offer strategic and practical solutions to the issues which clients face, whether it's in relation to succession planning, will preparation, probate and the administration of estates, immigration and visas, contentious family or probate disputes, administering estates often with inheritance cross-border issues, international trust advice including residence, domicile issues, wealth preservation, a fast, efficient service from SRA-regulated professionals, transparent pricing. BWF Solicitors, let us take care of probate. Welcome to BWF Solicitors, a trusted and experienced family law firm specializing in immigration and naturalization, as well as dispute resolution. Meet Bernard Owusu, our esteemed senior partner with over 30 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stand for integrity, respect, excellence, teamwork, diversity and inclusion, and service to the community. We provide tailored assistance across all areas of UK and Ghana law. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Led by experienced senior partner Bernard Owusu, the team at BWF Solicitors is ready to assist you with your immigration, naturalization, dispute resolution, family law, new wills and probate, Ghana law and practice needs. We are dedicated to providing solutions to our clients' problems. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Main office line 0208 493 7340 or our emergency line 07712 761 884.
Hello and lovely welcome to all of you out there. Another Saturday is here with us. We are live on BWTV, and by courtesy of BWF Solicitors, we're bringing you the community and the law. My name is Oriku Owusu Frimpon, and I have the privilege and the honor to be moderating the discussion. This afternoon, we're going to look at a very interesting topic. Now, when you live in the UK and you have got your indefinite leave to remain in the country, you could naturalize and become a British citizen. Now, in applying for that, there are things that people think are good. There are things that people think don't go their way, so they call it the bad. And the ugly, the things that you probably look at and think that it could have been better or have gone your way. That discussion is something you need to be a part of. So I'm inviting you to ask somebody, to ask another person, to also ask another person to come join us live on BWTV. We're also live on BWF Solicitors on Facebook and YouTube and all the other social media platforms. Now, later on, we will be activating the studio numbers for you to call in and put a question to the senior partner of BWF Solicitors and Ben on any legal matter, and especially your immigration matters. So you have to note the number 0208 493 7345, 0208 493 7345. You can text us on 07399 208 468. That's it if you are in the UK. If you're outside of the UK, 0044 7399 208 468. You can also send us a WhatsApp message or voice note 0044 79 504 22780. 0044 79 504 22780. Now, before we do that, let me go over and do the rightful and ask all of us to welcome our big man, the senior partner of BWF Solicitors, Mr. Bernardo. So we call him Uncle Ben. Uncle Ben, good afternoon.
Hi, good afternoon.
Thank you very much for joining us.
Thank you.
It's a lovely Saturday afternoon. I checked the temperature and we have moved into the doubles. And It was 14 this afternoon. I was like, okay, I don't need to put my scarf on. I don't need to put my jacket on.
Yeah.
It's a lovely day. How's the family?
Well, everyone is doing fine. All the boys, my daughter, my wife, family, dad and mom. In fact, it was mom's birthday a couple of days ago.
Oh, wow.
So she's 78 on the night. Well, on the 29th of January. So yeah.
God bless her. And we wish her the very best with a lot of strength and happiness, so we can all benefit from her wisdom. Mom, happy birthday to you. Yes, Uncle Ben is just received our greetings and felicitations. So we'll be moving to the deep end of our discussion. Now, earlier on this week, there were a lot of updates that BWF Solicitors have helped us with. And they started off on a Monday morning with a nugget. How to make an application to avoid the IHS increase before the 6th of February. Today is the 3rd of February. Is it the 3rd or the 4th? Yes, the 3rd of February. The 6th, tomorrow is Sunday, Monday is the 5th, 6th is the Tuesday. And how are we going to be able to meet and beat that deadline? Now, they are telling us that if you're in the UK and applying to extend your leave to remain, that is LTR, you may apply earlier than 28 days so as to avoid the IHS increase before February 6, 2024. There is no requirement that you apply 28 days before your LTR expires under the immigration rules. However, the guidance says that a period of unexpired leave up to a maximum of 28 days will be added to your leave if your application is valid and meets all the other requirements. Now, when you have more than 28 days left on your LTR, that is the leave to remain, that is where I think the however bit or the exception applies to you. The guidance says that the period of unexpired leave up to a maximum of 28 days will be added to your leave if your application is valid and meets all the other requirements when you have more than 28 days left on your leave to remain. This was published for Home Office staff on May 15, 2023. You know, when they are bringing up all these things, they plan so well ahead so that you will not have the excuse of saying I didn't know or you didn't want me. That's by way of our nuggets. There are a few updates that I want to really touch on before we go, but I will be asking Uncle Ben to help us unravel some of all those things, especially with the nugget. Now, in a community, what we need to know is that the minimum income threshold for skilled workers has been raised from 26,200 to 38,700. Watch that. The minimum income threshold for skilled workers is raised from 26,200 to 38,700. The Minister of State for Legal Migration and the Board, Tom Pesgrove, MP, has announced that from April 4, 2024, the earnings threshold for those on the skilled worker route would increase from 26,200 to 38,700. The health and care visa route is exempt from this change, as are workers in national pay scale occupation. If you want any further details, you need to contact the specialist solicitors group here at BWF Solicitors, and they will give you more information. But Uncle Ben is here, so he'll be highlighting that as well. The next bit is there's a difference between the one I brought earlier on. If we could go back to that so I can highlight the difference. The minimum income for skilled workers is raised from 26,200 to 38,700. Now the next one is minimum income threshold is raised from 18,600 to 29,000. That is for a different thing. So watch that, and I will get Uncle Ben to help us with that. So don't worry too much, but I wanted you to notice the difference. The Minister of State for Legal Migration and the Board, Tom Pesgrove, has announced that from April 11, and you see there's also a difference between when the previous one was starting, that was from the 4th, and this one says on the 11th. So note that the minimum income threshold for families will be raised from 18,600 to 29,000. In due course, it will be raised to 34,300 and then back to the 38,700 that initially they proposed it was going to go to. Now, the next one is healthcare sponsors can no longer sponsor migrants unless they have CQC. What is that? Uncle Ben will help us with those things. The Minister of State for Legal Migration and Border, that same man, has announced that from March 11, 2024, care sponsors can no longer sponsor migrants unless they are CQC registered. Now, watch this. It is not you that has been given the contract. This one is saying the sponsors, the people or the organizations or the persons that are employing people, and they can no longer sponsor migrants unless they are CQC registered. What is that? We'll be coming to that. And then finally, care workers can no longer bring their dependents. The same man says, from March 11, care workers and senior carers can no longer bring their dependent family members. From March 11, care workers and senior carers can no longer bring their dependent family members. Ladies and gentlemen, I think I've given you too much information, but let's go break that down. Uncle Ben is right here, and with him, everything is easy as ABC. And from 1, 2, and 3, we can get it right. Uncle Ben.
Okay, so the announcement obviously was preempted just before the end of the year, and the Prime Minister at Houses of Parliament did announce that there was going to be a groundbreaking change to reduce net migration, by about 150 to 200,000 a year. And for that reason, they introduced IHS, which you've mentioned, which starts on Tuesday. It goes up from £645 a year to 1,035 a year, and therefore for a typical application of 2.5 years, the difference will be £1,117. So that's there. Then from there, which this is Tuesday, and then we move into March. We go to the 4th of March, and then the 11th of March. From the 4th of March, people who sponsors workers to come here only in the skilled migrant route under health and social care cannot sponsor anymore if they do not have a CQC registration. CQC stands for Care Quality Commission. It's a regulatory body for people in the healthcare industry who dispense medication. So if you're in the healthcare industry and your role is not to dispense medication, then clearly you don't have to register with the CQC. You can continue to do your work, but you will not have a license to bring people from outside the UK and to employ people in the UK. Now, just watch also. It says that they must have, which means that if you don't have, it's very possible that they may revoke your license.
Yeah.
And these are some of the problems that we have. We may need a bit more clarification later. But for now, every person that I know who doesn't, they've all applied, and some of them have had interviews and inspection this week. Then the big one, which is the income threshold for families.
Mm-hmm.
Now, this is where we have a big problem. Now, when they started, they were going to increase it to 39,000.
Mm.
And, we stepped in, people signed petition, it went to the Houses of Parliament. Because it passed 100,000 signatures, they then looked at it. Their response was that we are going to stagger it. Now look at the way they intend to stagger it. Mm-hmm. They start with the 29,000 on the 11th of April. That is guaranteed. Mm-hmm. It will happen. Because they're going to introduce a law in Parliament in March, and it is deemed that by the 11th of April, the law will kick in. There's nothing anybody can do about that anymore.
Right.
What we can work on is that they said in due course, it will be raised to 34,300, and then in 2025 to 38,700. That is what you can do something about.
Okay.
The other difficulty I have to raise with this is currently the income threshold of 18.6 prevents about 35 to 40 people from joining their families.
Mm-hmm.
It is estimated that over 75 families will be divided by this new threshold. So from 18.6 to 29. Next week, maybe we will talk about, even if you don't meet the income threshold, you can still bring your dependent family member or your husband or your wife under what we call the GEN 3.1. We will discuss that next week. But for now, the focus is on what is happening. So everything is in our hands. We've got today, we've got Sunday, we've got Monday. Tuesday is a cutoff period for the IHS. At most applications, the applicant will pay the IHS, from skilled migrant workers to families. If somebody is coming to live here for more than 6 months, not indefinite, but for more than 6 months, the Immigration Health Surcharge Regulation requires that you pay Immigration Health Surcharge at the current rate. That is going to go up. Now, for those people who are here and those who are outside, if you're making a family law application, either under Article 8, most family applications will be under Article 8, either to join your husband, your wife, your children, or your parents will be under Article 8, or here as a spouse, you can apply for a fee waiver. We've discussed that at length the other time. We will discuss it again. And for those people who are skilled workers, this exempts care, healthcare. So healthcare, you are held in high esteem. Mm. There are problems with the healthcare industry. We've discussed that at length. Somebody will say ad nauseum, which means too much. And therefore, we know what the problems are. Mm-hmm. So in one breath, they defend you, protect you. In another breath, they expose you. So they protect you. You're still under shortage of occupation, which means that you get a discount. The 20% discount is going to be removed very, very soon. So those people on the £10.75, very likely that they will get an additional 20% on that, which will be maybe about another £2 or £3 extra. You also defended from and protected from the increase in the minimum income threshold, the MIT. So you're not going to 38,200. You're still £10.75 with a minimum of 37.5 hours. That gives about 20,290 thereabout. That protects you. But please, we've said this, we've explained, we've sent out videos, we've done flyers, we've called, we've texted, we've highlighted, we've encouraged, we've announced. If Monday passes, you will have to pay the extra money. Kweku, it is steep. It is steep.
Yeah, it is.
Currently, it's 1,560 just for that. If
it's
you
going
add
up about 60%.
Yes, and if you add the immigration application, it's 2,650 thereabout, slightly more than that, but it's going to go to 3,000 plus, and that is why we've been saying this. Listen, even if we keep saying that you haven't got the things that you're waiting for, it might be pay slip or bank statement. Speak to a lawyer, and not just any lawyer, a qualified lawyer, because these days many people call themselves lawyers when they are not. So speak to a qualified lawyer, somebody who has experience in this area, who can help you to crack it, so that we don't want you to pay. The nugget will also lead us to something else, which is very, very important. And I think people must know that as well.
It dovetails into that. Let's look at what the nugget says again. So we'll get you to help us to do that. How to make an early application to avoid the increase before Tuesday, the 6th of February. So if you're in the UK and applying to extend your leave to remain, you may apply earlier than 28 days so as to avoid the IHS increase before the deadline, which is the 6th of February 2024. There's no requirement that you should apply before 28 days before your LTR expires under the immigration rules. But the guidance says that the period of unexpired leave up to a maximum of 28 days will be added to your leave if your application is valid and meets all other requirements when you have more than 28 left on your LTR. There's a bit of some calculation here, and if we're not careful, we'll miss what it is and what does it say. 28 days before your thing expires, you can apply. And when you do apply, is the nugget saying that they will add that 28 days to when they grant your thing or what?
Okay, so I'll give you two scenarios. So there's someone whose leave, let's say, expires in March, let's say on the 30th of March. Today is the 3rd of February. So they make the application today. Obviously, they have more than 28 days left on their visa. So let's say he goes in, he's done a priority application, they'll grant him, but he's got a month plus. They can only add 28 days to your visa. Does it matter? I'll explain why it matters. It matters because it saves you money. You can make an early application. I will use maybe May, say the latest. So if somebody's leave is expiring in May, I can confidently say that you can apply now. You have about 6 weeks to enroll your biometric. I think it's 40 days. And therefore you can delay that. And when you book that, again, you can delay that as well. I will explain. So there's no law in our immigration rules which says that if they give you 2.5 years today, tomorrow you cannot apply for another 2.5 years.
Okay.
So when people say the earliest time you can apply is 28 days, there's no law. There is in the guidance and advice by the Home Office that the earliest time you can apply is 28 days. But it's a guidance. Guidance is not law. if a law gives you a right, if the immigration law gives you a right, and the right is that you can apply anytime, and the guidance takes away your right, and the taking away is that no, you can apply only 28 days at a time. There's a case law called Pankina. Everybody can remember because the name is funny. Pankina, which is a court of appeal case, and then there's a case, another case law called Alvi, which is there, which is a Supreme Court decision which applied the case of Pankina. What it says is that where the immigration laws gives you a right or a positive right, a guidance note cannot take it away. So if the immigration law says that you have what we call evidential flexibility, if you make an application and you're missing a sequence of documents, the Home Office ought to alert you to bring the sequence of documents. And then the guidance says, if you make your application and you miss one bank statement, we'll refuse your application. That the guidance note is taken away from you. But if the immigration rule says that when you make your immigration application and you miss a bank statement, even for a month, we will refuse you. And then the guidance knows if you make your application and you miss a bank statement, even for a month, we will not refuse your application, we will call you. The law says we will refuse you. The guidance says we will call you. The guidance is giving you more rights than the law. So the guidance will override the law. That is the essence of Alvi and the case of Pankina. So the immigration rules does not say the earliest time you can make your application is 28 days. Where you find that is a guidance note, which is a 15th of May 2023 guidance note, which says that the earliest time you can make your application is 28 days. However, if you make your application earlier than 20 days, then the leftover, we will only give you up to 20 days.
Okay, so if I applied 28 days before it expired.
Yes.
Or even more than 28.
Yes.
What they are saying is that, yes, they will add on, but up to 20 days.
Absolutely.
Okay.
But they didn't say they will refuse your application.
That's right.
That is why I'm saying that the cost that they've given is steep. The increase is steep. I am helping my community. So this is what we always do. But I'm happy to share that I am saying, now, to do this, you have to be confident. So first of all, many people, in fact, majority of lawyers will tell you, no, you cannot make your application 28 days before the time. I'm saying you can. Well, I said it before.
The law doesn't say you cannot.
No, the law doesn't say you cannot. It is a guidance that we say, the guidance did not even say you cannot. It says you can make it 28, but if you make it more than 28 days, we will add the extra up to 28 days. But we're saying you've got a strong right, positive right under the law. The guidance knows cannot take that away. That is all I'm arguing. Therefore, I'm using May as an example. Somebody asked me 2 days ago whether if he's going to expire, if his residence is going to expire in December, he can apply now. Absolutely not, you can't. First of all, your application stays online for 6 months. Okay? Is it 60 days or 6 months? I think it's 6 months. After that, it will go. The second part is that when you make your application, under paragraph 34 of the immigration rules, it refers to a valid application. So when you make your application, the application ought to be valid. Ought to be valid means that you've used a prescribed mode and form to make your application. You've paid a prescribed fee, you've paid your IHS, and in addition, you've enrolled your biometric details. That is a definition of a valid application. So if you pay your fee, you use the mode prescribed, and you don't enroll your biometric, within the time given you, and that is 40 days. So if you apply now because we want to be Tuesday, your visa expires in May, you apply now, you enroll your biometric in 40 days, which is about 6 weeks. So that takes you to somewhere April, I think. It takes you somewhere in April.
Yeah, 40 days. March is February 29.
Yeah.
March is 30.
Yeah.
So you're about over 40, almost 50.
Yes.
50 days.
Yes. So that takes you closer to the 28 days. But when I'm dealing with this, I'm not worried about any 28 days.
Mhm.
The only time that you cannot make an application earlier than your required time is when you're applying for indefinite leave. So when you're applying for indefinite leave, they always say that as a family member, you've either been on the visa for 5 years or for 10 years. So if it says 10 years, you cannot apply 9 years, 8 months. It has to be 10 years. If it says 5 years, you cannot apply 4 years, 10 months. Right? It ought to be. But Kweku, the application process is complete when your biometric is enrolled. So again, you can delay the process. You put in your application, you pay your fee, you fold your arm.
And by time before you do your biometric,
you give it a couple of weeks, or even the following day, you can book your biometric. You can cancel the same biometric and rebook it again. You can always do that. And it's a trick in the trade that we use. I'm happy to share, because this is going to save potentially thousands of pounds. Typical family with 3 people, they'll be saving over £3,000. So I'm happy to share. It's an industry knowledge. Not many people know, because they are still stuck with the 28 days, which doesn't exist. However, I say to you that if you don't understand, speak to a qualified lawyer.
It's all on the community and the law, and brought to you by BWF Solicitors, our trusted legal partners in the community, especially here in the UK. BWF Solicitors, they are on the 4th floor of the Anna House, 214 to 218 Tottenham High Road, Seven Sisters, North London. They work Monday to Friday between 9:30 in the morning and 6 p.m. in the evening. Call them on 0208 493 7340. You can find the numbers at the bottom of your screen at the moment. They have an office in Ghana, and if you would want to consult them or contact them, 00233 55 589 5959. Very simple number. 00233 55 589 5959. And all over the world, in cases of emergency, just call 004477 127 61884. 077 127 61884. So for all your immigration applications, for all issues when it comes to the law, and with the community empowerment that they have always been pursuing, you can join legal programs on Thursday on Rainbow Radio, Friday on BWTV, and Saturday on the Community and the Law on BWTV. All of them live on BWF Solicitors Facebook page, YouTube, and all the social media platforms. Well, my friends are here. We have Debbie Adu, you are watching with us. Patrick Mills, you're watching with us. Dr. Zakwa, thank you very much for watching with us. Kwekuba, we are here with you. Evans Yantra Esiama, you are watching with us. Diana Tutu, thank you. Ya Odru, thank you. And Passmore, you're watching. Collins Okomens, you're also watching with us. Let me pick up the earlier ones. Arba Akwe, you are with us. Sajiba Emmanuel. Demonunkum is here with us. Anita Japoma Japong is watching. Chi Wo, thank you very much. Stephen Kwekwansa, Usu, you are here. Abraham Adu Mensa, Doka Sopoku, Linda Asante, Fred Dapa, K. Fosubaden, Asari Williams, and Tex Christian is also watching. Kwame Lewis is here. Gertrude Latte, Sheila Upton, and also with us Samuel Ngoma. Louisa Santos says, Margaret says, share. Glorious evening, Uncle Ben Brakweku and lovely family. Good vibes. That's for Louisa Asante watching us live on YouTube. Mina Nkoma, good evening. You're watching us on YouTube. Thank you so very much. So when you come on board, Awo Ohima Frimpoma, you live with us. When you come in here, please click the like button, pick up the link, share, and also click on the notification button so that when we put content on our page, you will be notified and you don't miss anything. It's live on BWTV and it's the community and the law. We'll be right back.
Welcome to BWF Solicitors, a trusted and experienced family law firm specializing in immigration and naturalization, as well as dispute resolution. Meet Bernard Owusu, our esteemed senior partner with over 30 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stand for integrity, respect, excellence, teamwork, diversity and inclusion, and service to the community. We provide tailored assistance across all areas of UK and Ghana law. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Led by experienced senior partner Bernard Owusu, the team at BWF Solicitors is ready to assist you with your immigration, naturalization, dispute resolution, family law, new wills and probate, Ghana law and practice needs. We are dedicated to providing solutions to our clients' problems. You can find us at the 4th floor, Anna House, 214-218 High Road, Seven Sisters, London, N15 4NP. Main office line 0208 493 7340 or our emergency line 07712 761 884.
Hello, thank you very much for sticking around. Now, let me ask you the question. Are you ready to apply for your British citizenship? How do you even qualify to be able to make that application? But when you're doing that application, listen, there is the good things about that. There are the bad things that you need to know, and also the damn ugly about them. But I'm going to get you to be so relaxed about that, because today on the program, we're going to look at how to make that application, how to avoid the pitfalls, how to make the ugly ones look very beautiful, and to stick to the very good. And earlier on, we had the senior partner BWF Solicitors and Ben giving us details as to what updates there are. Please, if it is that you would want to consult any reliable lawyer and those who know what they are doing, please, I recommend that you go to BWF Solicitors. Visit them on the 4th floor of the Anna House, 214-218 Tottenham High Road. If you go by public transport here in the UK, go on the Victoria line and get off at Seven Sisters. When you get off the train at Seven Sisters, use exit number 2. That will take you to the entrance of the Anna House. Climb up to the 4th floor, and BWF Solicitors will welcome you. It's the only organization of Ghanaian descent that gives you the Ghanaian chocolate. The King's Bite is my favorite. So be there, and whenever you get there, tell them Kuku says you will give me chocolate. They will do that. They'll give you that. But no, let's go and learn now. Uncle Ben, British citizenship. Sometimes people confuse naturalizing with being a British. When you naturalize, does it automatically make you a British citizen? And with that clarification, can we look at how we can apply for a British citizenship?
Okay, so we all know that British citizenship is the ultimate.
Okay.
So our topic is the good, the bad, and the ugly. So in itself, those people who are registering as British citizens will usually be children under 18 and certain category of Commonwealth citizens or citizens of the United Kingdom and colonies. They can register. Registration is different from naturalization. Registration is by right. Naturalization is by discretion. Certain aspects of registration is also by discretion, which is a child who wasn't born in the UK and is applying because his parents are applying. Within the law, the relevant provision, if you take the 2022 Immigration and Nationality Act, you take the 1981 Nationality Act, there are two main provisions for people to naturalize as British citizens. So when you naturalize, you become a British citizen and you are not entitled to a passport, but there has to be a justification why you cannot apply for a British passport.
Okay. So the process is you would have to be naturalized before you can apply to become a British citizen.
Okay. When you naturalize, it means you become a British citizen.
Okay.
You have a right of abode under the 71 Act because you will be above the immigration rules. You're not subject to immigration control.
Okay.
So if somebody says, I'm applying for naturalization, it means you're applying to become a British citizen.
Okay.
Yeah.
Okay. All right. And that's for people applying under the immigration rules. What about those who have moved from Europe to become citizens? Maybe I put in quotes. Do they have to go through the same process?
Okay. So if you look at Section 1 of the British Nationality Act, Section 1, we have 1.1, 1.2, 1.3, 1.4, even under Section 4.1, there are people who are born British and they are British citizenship by descent or otherwise by descent. By descent means you acquire British citizenship through your parent. So for example, if you have a child, your child will become British because you have British citizenship or you have indefinite leave. So the child would have acquired British citizenship by descent.
Okay.
If you acquire British citizenship through registration or naturalization, you are a British citizen otherwise than by descent. So you can pass on your citizenship, but only so much. It's the same way somebody who was born a British citizen and acquired it through descent can pass it on, but only so much.
Okay.
So the difference is for those who are born British, they are British. For those who acquire it, they either acquire it by registration or by naturalization. And the moment that you're naturalized, you have become a British citizen.
Okay.
Yes.
All right. Now, I would ask, it might sound a bit naive, but let me ask, why are we saying there's a good about it? Why are we saying there is the bad? And why would it be ugly?
So when you look at British citizenship, it is the ultimate. So many migrants aspire to be British citizens.
Mm-hmm.
That is why there's a need for people to understand the process that takes you there. Within the rules, there are the good bits, and then within the rules, there are the bad bits. So the good bits we will discuss, the bad bits we will discuss. But British citizenship under naturalization is a privilege and not a right. So nobody can say, well, I've lived here for 5 years lawfully. I've got my indefinite leave. I'm married to a British citizen, so I have a right. Give me a British citizenship. No, it doesn't work like that. So when you get it, that is a good part of it. The bad part is certain people are not aware of things that may affect them, even if you don't pay your council tax.
They could take it away.
Oh yeah. Well, not they could take out. You may fail in your bid in your application to become a British citizen.
Okay.
The other part is those people who have been subject to corruption in the country where they come from. So if somebody has been investigated for corruption and corrupt practices, let's say in Ghana, and they're found to have been complicit by either an investigatory body or some other part, then again, that's the ugly bit you don't. Notoriety, we will list them when we come to them. If a child belongs to a gang membership, they do all the bad things that they do, it can affect the parent. And those are the things that we refer to the ugly part. The ugly part is that there are processes like what Al Fayed went through, which is unexplained, undiscussed, shrouded in secrecy, and because there's no right of appeal, sometimes you may not know. If you look at the guidance notes to nationality, even under the character requirement, there's somewhat, but they say this is secret. We will not tell you. So those are the hidden bits. But today we'll try and put everything together. We go through the good, we'll go through the bad, and then I will highlight broadly what the ugly parts are, including those who have it and may lose it. We've discussed that before, but I need to bring to the attention of people that the fact that you've got it doesn't mean that you cannot lose it. You can lose it, that you need to watch certain things that we do as a people in this country.
So if you just joined us, we're looking at applying for British citizenship. the good, the bad, and the ugly. The senior partner for BWF Solicitors, our trusted partners when it comes to the law here in the community. Here, he's here with us and is helping us look at that. So come join me and let me ask. First of all, let's unravel it one after the other. The good.
So the good bit is, it's straightforward. So you come to the UK, you abide by the laws, you come here, maybe you overstayed a bit, you've regularized your stay, you're not married to a British citizen, but you've lived here lawfully and you've got your indefinite leave to remain. So you want to go and apply. Now, the good things that they will consider, and this is something that people don't pay attention to. Voluntary work, doing things in your church, helping the aged, helping the school, even where your kids go to school. Sometimes when they're going on trips, you go and help and all those things. You get a thank you letter from the school. You know, you go and serve tea and coffee at your local nursing home, for example. You do it free of charge. You know, I have people in my family who go to nursing homes and go and cook for them for the Christmas holidays. And they get a thank you letter, they get a card. Those are bits that you can use for your application.
Okay.
So these are things that people don't know. And even if you don't meet the rules, because it is discretionary, if you have positive things in your life, you can add it and say, although I don't meet this requirement, because of this positive thing, because the Secretary of State, you have a discretion, please, because I do this and I do that, because I've done that, because I help this woman, because I do shopping for my next door neighbor who is written a letter for me. His daughter lives somewhere 40 miles away. So clearly when, you know, he wants to even do his pay for his electricity, pay as you go, I do that. And, you know, he's got a letter. Or I go and help with my local charity shop. I go and sell stuff like that. Or I dedicate myself to do this with young children in my local area. Or the youth club, I go there and play football with them. These are positive things that you can add. But the rules are very, very clear. The rule says that British nationality is not a right, it is a privilege. That's the first thing you have to remember. It also says that under Section 6, we have a Section 6.1 and Section 6.2. Under Section 6, the Secretary of State can exercise discretion, but there are certain requirements that you have to meet. 1, age. You have to be 18 and above. 2, you have to be of full capacity. Somebody will say, but lawyer, you said 18. You're also saying full capacity. What is full capacity? Full capacity means that you have the mental capacity to decide that you want to be a British citizen. Okay. The fact that you have been sessioned in a mental home doesn't mean that you don't have the full capacity. The other bit is that you meet the language requirement. The other bit is that you meet the life requirement. The other bit is that you meet the residential requirement. And the other bit is that you meet the character requirement. There's no definition of character in the law, but character itself broadly can be defined under Section 51 of the British Nationality Act as any behavior which is repugnant to the British or breaches the British law. So anything from your financial soundness to notoriety to association to criminal conviction, criminal conduct, immigration breach, all these are lists that can affect you. So the positive side and the good side is that British nationality is the ultimate. Once you acquire that, you are above immigration control. So when you arrive, you can, you know, push out your chest and approach the immigration officer. In fact, these days, you don't even go to the immigration officer.
Yeah, because
you swap your passport and then you go through. That's correct. That's correct.
That's real easy and convenient, especially when you arrive at the big airports and there are about 4 or 5 flights that have come at the same time, and you have to queue for more than 2 hours. It's something. If you haven't gone through that, sometimes you regret that you arrive very early in the morning. But well, hey, that's what it is. But if you have that privilege, as Uncle Ben is saying, the good bit is that there are certain things that you can really enjoy and make life easy for yourself. That's a good part. And why are we saying there's a bad part? Could there be things that are being hidden in the rules and the regulations and other things that could go against you? Let's go back to Uncle Ben and say,
so broadly, on the bad side, we know that if you've got a criminal conviction, you will be barred. So I will start with the top and I will work our way down.
Okay.
If somebody is convicted and sentenced, so it's not only conviction, but convicted and sentenced to a term of imprisonment of 4 years or more, you can never become a British citizen. Never.
4 years or more?
Or more. You can never become a British citizen.
Okay.
If you're sentenced between 1 year and 4 years, or under 4 years, then it will take you 15 years from the date of conviction and sentence to apply for British citizenship.
Okay.
If your conviction is less than 12 months, then it takes 10 years.
Can you go over that again?
Okay. So 4 years and above, 0. You're a persona non grata.
You can never
become a British.
Okay.
12 months up to 4 years. So not 4 years, because I said 4 years and above. So 12 months and under 4 years, you will take you 15 years from the date of conviction to qualify for British citizenship.
Okay.
If you're convicted for 12 months and below, it would take you 10 years.
Now, if you say convicted, it means that you would have gone through the due process of the law. A competent judge would have sentenced you to that period in prison. In that case, be assured that it will be on your record, and it will take you, if your conviction is up to 12 months, it takes you 10 years.
That's correct.
Beyond 12 months, and less than 4 years, 15 years.
That's correct.
Anything above 4 years, forget it.
Yes, you can never, because it will never expire. You can never apply for British citizenship.
Let me ask this. It might not be a conviction, but there will be a criminal record on your, or an item on your record.
Yeah.
You go to do your enhanced DBS and it brings up something.
Yes.
So the disclosure is there. Would that affect your British citizenship?
Yes, so that is a bad part.
Okay.
So we've talked about the good, we've talked about the ugly, which is the upper bit, and other things that I will talk about. And then the bad side is there are things that we take for granted, what I want you to watch.
Right.
So if you owe the NHS of £500 or more, if you owe the NHS of £500 or more, and you have not put in place arrangements to pay, your application will be refused.
Owing the NHS?
That's correct.
Okay.
Now, somebody will say, but why would I owe the NHS if I don't pay for NHS? Well, there are times that people, maybe you came here, you were illegal. You use a secondary NHS. GP is free, and that's why when I hear people say that the GP said, go and bring your passport, I don't understand. The NHS say the GP should not ask you for your passport. But when you do secondary treatment, if it's not a communicable disease, it is paid. So you go and give birth, you have a cancer treatment, you have an accident on the road, you're treated, they are all chargeable treatments. Okay. So if they charge you because you didn't have any papers, and let's say somebody called me the other time, they've been charged 7,000. They haven't paid that. They managed to get their settlement. They want to go and do British citizenship. They've forgotten that they were owing 7,000. The Home Office will scan the system, and if the NHS had asked you to pay the money and you haven't paid, they will remind you to go and pay that money.
Or make an arrangement.
Or make an arrangement to pay.
Okay.
And if you don't do that, they will refuse your application. They are very good about that. They don't refuse it straight away. with a British nationality, they are very careful with applications. So if they find something wrong with the application, they'll write to you and say, this is what we found. What do you say about that? Before they refuse it. If you owe council tax, you owe council tax, and you take steps not to pay. Remember that when you owe council tax and TV license, although TV license is not part, it can be part, and I'll explain why. So the little things that people don't
take for
think,
granted.
and that's why we're doing this, the good, the bad, and the ugly, because there's such hidden issues that we don't know. So if you owe council tax, the guidance knows that if you have been unreasonable in paying the council tax, because you can go to prison for council tax payment.
Definitely.
So this is not a time that you've gone to prison. This is a time that you have unreasonably failed to pay your council tax. They'll refuse your application, because the law says that British citizenship is for those who have respected the British law. British law, it's just like Ghana, we pay taxes and we're grumbling. The council tax, like in my area, I was just told this week that they're now going to collect our rubbish once every 2 weeks. Well, they alternate on the brown and the blue. Once every 2 weeks, because somebody's used 500 million pounds of our money to go and do gamble somewhere. So we haven't got money in the borough. And there are about 14 of boroughs who are now bankrupt. So the council tax is good money for them. If you don't pay your council tax and you're unreasonable in paying, it could affect your British citizenship. In fact, it says you should be refused. If you don't pay your tax, your HM revenue assessed tax, they will refuse your application. If you don't pay your TV license, it could affect you. If you owe money, just owing money itself is not a reason to refuse you. But if you are, because I've done an application where we've disclosed that the client has judgment debt, or whatever it's called, county court judgment debt.
The CCJ.
They've written to us and say, please show us the steps your client is taking to pay this money. I said, Jesus Christ. So I called my client and I said, oi, you know what? We need to put something in place. So for 2 weeks, he was arranging. I mean, the other side didn't know that that's why. If they knew, they would have said, no, pay us all our money, else this is going to be refused. So the guidance notes, and please, you remember I used Pankina and Alvi. I said, if the law gives you something and the guidance note takes it away, then the guidance notes cannot take it away. So you always must check what the law is saying about character. And I said there's only one definition of character. There's no broad definition. It says that someone who respects our laws. So you cannot say, oh, but you didn't put in the immigration rules, nationality rules, that if I don't pay my council tax, I will not get British citizenship. Because when you go to section 6.1 and 6.2 and schedule 1 of the British Nationality Act, there's nothing there which says that if you're this and that, you won't get this. The other thing I want to add is notoriety. So when we say somebody's notorious, somebody's notorious big, it's not a musician I'm talking about. I'm talking about somebody who is notorious for a bad reason. Now, the notoriety may be sound noise abatement notice, your child being part of a gang, you yourself being part of a gang, and again, financial soundness. So if you don't have financial soundness, you're bankrupt, you've done a voluntary arrangement, a VA, or you owe money, a lot of money from banks and credit cards, and you're not paying, all those things can affect your British citizenship application.
So can somebody who, one way or the other, has cheated the system, the benefits and other things, can that go against the person?
Yes. One of the bad aspects is that if somebody is claimed benefit and they were not entitled to claim, and they've been found out, that will affect your British citizenship. Because broadly, the definition of character is that someone who has respected the British law. So if you don't pay your council tax, you don't pay your tax, you don't pay, if you're an employer, you've collected NI from your employees, you don't pay them, or if there are other things that affect you, you've claimed benefits and you shouldn't have claimed. You've claimed child benefit when your child has been in Ghana for 5 years and you're still claiming child benefit, and then you're found out. This will affect your British citizenship.
If you just joined us, we are on the program The Community and the Law, and we're doing that by courtesy of BWF Solicitors. We're looking at the topic applying for British citizenship, the good, the bad, and the ugly. The senior partner for BWF Solicitors, Mr. Bernard Owusu, Uncle Ben we call him, is with us as a resource person, and he's taking his time to really unpick all those issues, open them up, and shown us what needs to be done. How do we avoid the bad? How do we avoid the ugly, which is, if I will put it, the upper limit of the things that we don't want to hear or see? These are the things we are looking at. If you have any question, you can text to 07399208468 or send a WhatsApp message to 0795042278. The lines are active now. 0208-493-7340. Or you can go to the comment section on YouTube and Facebook and leave them there. I'll be picking all these when we come back. It's all about you and the community. Of course, the law as it applies to you. We'll be right back.
Our private client services team is recognized for providing clear and practical legal advice to our clients in the United Kingdom and Ghana. Expert help with will writing, probate or estate administration. Our will writers and probate lawyers can act for you to obtain grant of probate and carry out estate administration on your behalf. The probate takes place after someone dies. If there's a will, the named executor is responsible for ensuring that the estate of the deceased is secured, assessing its value and paying any inheritance tax. If there is no will, the interstate and inheritance rules require similar responsibilities. Our lawyers offer strategic and practical solutions to the issues which clients face, whether it's in relation to succession planning, will preparation, probate and the administration of estates, immigration and visas, contentious family or probate disputes, administering estates often with inheritance cross-border issues, international trust advice including residence, domicile issues, wealth preservation, a fast, efficient service from SRA-regulated professionals, transparent pricing. BWF Solicitors, let us take care of probate. Welcome to BWF Solicitors, a trusted and experienced family law firm specializing in immigration and naturalization, as well as dispute resolution. Meet Bernard Owusu, our esteemed senior partner with over 30 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stand for integrity, respect, excellence, teamwork, diversity and inclusion, and service to the community. We provide tailored assistance across all areas of UK and Ghana law. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Led by experienced senior partner Bernard Owusu, the team at BWF Solicitors is ready to assist you with your immigration, naturalization, dispute resolution, family law, new wills and probate, Ghana law and practice needs. We are dedicated to providing solutions to our clients' problems. You can find us at the 4th floor, Anna House, 214-218 High Road, Seven Sisters, London, N15 4NP. Main office line 0208 493 7340 or our emergency line 07712 761 884.
Welcome back and thank you for sticking around. We're live on BWTV, live on BWF Solicitors Facebook, BWF Solicitors YouTube, and we're doing this courtesy our trusted legal partners, BWF Solicitors, the community and the law. Applying for British citizenship, what are the good, the bad, and the ugly bits about the whole situation? Uncle Ben is here and he's looking at that. Now, Uncle Ben, how can we make the ugly bit good? Is there anything we could do about that? For instance, you said that if you have had a sentence and it's 4 years and above, forget about it. Can we mitigate that?
Well, there are people who obviously are stateless. But if somebody is stateless and they are recognized as stateless, they will have residency. So the fact that you don't have a British citizenship does not mean that you cannot continue to live in the UK. And as they've said, British citizenship is a privilege. It's not a right. Indefinite leave is a right. It's not a privilege. So that is it too. If you don't get indefinite, it affects you in so many things. If you don't get a British citizenship, really, the only thing that it affects you is residence. Now, the ugly bit is the gravity of the offense, the effect on the nation and the people and the victim. If we take things like sexual offenses, if you look at the Sexual Offences Act of 2003, for example, there are punishments like registering with the police, putting your name on the sex offenders list, and other things. There are also offenses that causes harm, although it may be like yesterday we saw the guy who's poured acid on other people. It turned out that it's his ex-partner and her child, and obviously that is cause harm to a person, a serious harm. So those are offenses that rise the country, that people rise up, like the Shipman offense. Dr. Shipman went about injecting people and killing them. So offenses like that is going to be very difficult. But at the beginning, I said that in all your application, you can mitigate because there's discretion. Even where it says that this should be refused, the Secretary of State has a discretion not to refuse the application. I normally use the R-Fired description. R-Fired, all he did was that he gave bribes in brown envelope to conservative MPs. And then his typical loudmouth, he came out and said it. And there were other people whom he gave Rolex watches to. And again, he said it. So for being outspoken about influencing politicians in parliament, he was punished. He was never given a British citizenship until he died, although his wife was a European national. So those are some of the things that we say is unfair. At the time, there was no way you could challenge it. Now you can challenge it by judicial review or even by an administrative review. But there are things that I always say that they are the little things which are the bad things that we should all watch. But the ugly bit sometimes is so difficult that you cannot succeed on the ugly bit.
Okay. Well, we are live on the program and we have, as I said, activated the line 0208-493-7345. Uncle Ben is here and he's going to take your calls as they come in. I've got a few of them as text messages and comments on the page, which we'll be picking up. We've got somebody on the line. Hello.
Oh, hello. Good evening. My name is KK. Greetings to you and Uncle Ben.
Greetings to you too. Thank you for calling.
Thank you. Right. My question is in respect to young adults taking advantage of the new provision, the 5-year provision under the private life. I've seen a friend of mine's child's grant letter. Right. The way I understand the law, okay, for one to take advantage of that, when you are applying, it means that your leave must have been granted under the private life. Right. If so, now the letter says the leave was granted under family life. I think when they made the application, they made it as a family unit. However, at that time, the young adult, met the private life provision. So the letter should have stated that he was granted under private life, but it wasn't. So now that this provision is in place, and then you want to apply for the settlement, because his current leave letter do not state the private life, am I right to say that he is not qualified to apply for the 5-year settlement, which means that he has to first apply for private life, what's it called, a leave under his private life, and then immediately apply for the 5-year settlement. I know it will be quite expensive though, but then when he applied, he met the private life rule, and it should have been granted under private life. Can he go back to the Home Office to say that, oh, hang on, I did meet that provision at that time, but you made a mistake, and I just found out. Is there any way you can correct it so that I can apply for my settlement? Uncle Ben, can you kindly advise the best way forward, please?
Okay. Well, the question you've asked, if I've understood it, is that you believe that for children who obviously have stayed on their private life route or have had lawful residence for 5 years and are applying for indefinite leave, or those who were born here and have lived here for 7 years and are applying for indefinite leave, they should have been granted leave under private life. Is that what you're saying?
Yeah, he wasn't born here though, but
yes,
he wasn't born here.
So he's under 25, but above 18.
Yes.
And how long has he lived here lawfully?
Hello, can you do your line is a bit faint. Can you repeat that again, please?
How long has the person lived here lawfully?
Oh, he's been here 5 years.
Lawfully?
Yes, but his current leave was granted under the family as a dependent, family route. That's what the letter says. It says something about it was granted as a dependent, because I think they applied as a family unit. But it doesn't say anything like a private under the private life.
Yes.
Of the young adult.
Yes. So the young adult is dependent on the family.
Yes.
And you want to take advantage of the concession.
Yes.
But why do you say that the leave will only qualify under the concession if it's granted under private life?
Because I think I was reading something on that. Is it PA 11.3 and then the PA 41? It's a bit not clear.
Why don't you share? Maybe if you send it, we'll put it on the screen and we'll all go through. I like doing that. So you share it. You've got my mobile. You've got line. We will look at it and then maybe we'll advise other people. But a leave is a leave. It says lawful residence. Most of these children would have been given under private life because they start off, but some of also would have depended on their parents. There are two categories, and the law doesn't discriminate between the 18 and the 25, whether the route that you came on is private or family. They are all Article 8 and lawful residence. KK, share, let's see, okay?
Okay, thank you very much.
You're welcome.
Thank you. I think it's a bit clear. I was a bit confused. Okay, thank you very much.
Okay.
All right, so we go on to the lines again, 0208-493-7340. Hello?
Hello, Uncle Ben.
Hello.
Hello, good evening.
Good evening.
Yeah, good evening.
Good evening.
Me pacho, me tumia kachi kaka.
Bacho kasai too.
Me pacho, me se me bisa Uncle Ben say, say bia, maame wo no say ojina ne ba no so age en krata. O to me application e de to me di 1 year na.
Ohima, bet me di 1 year. Almost overstay, you know, ni service standard. Nti normally no, see your application aya ye hwe bibi your friend of service standard. Nti sa service standard no, or see okay application way ebedi say. But home office for omo yan kola bone. Even the omo qualify under service standard no. Obetro say we case in a complex. Nti ye yin free service standard, ye na koto non service standard. Which means omo entimi ndi omo ade omo ahye no so. Enti it could take a while. So we'll be your application di 1 year. My advice is on home office on our money lawyer and no bisa the entia ache. Sometimes say family year application na kola woman be a kola from 14 ade kona na echesa na aya me very careful because it be na kola ni bi akoye bone ye investigate but ne maame na nya we ye nya case bi sa maame ne die bobo sa e kire ye kopusu no nunum no na kire se de e wo ne sa akola na di nsemo ne baako ama ne time apa ho ama wasa akodi biom nti no na akotwe abusuafo ne nyina application na kye no ba menka se sa no bia de atie de meka na se bisa won na pusu nunum nim ne ye nhwe why yes, what's he talking about? No.
No me pese me kate. Time na mimi ane pa ina opewo ye no. Owo ne ba no ba mu as students but wa anko school no. Oh. Into okowo ne ba no. Or nya normal delivery na o man draw letter say bi our book na bibi because we be rare as students. No we tia na NHS bibi answer all ba. Into owo no man brand ke bia. But so yeah, application no. Check 1 year ni. And I me book mention the passport for no woman kasa ho. Migration for na je.
Okay.
No mo be airport.
Oh, obedu airport no mo je.
Omo je ne passport no.
Na say only
leave. No, you photocopy na to so the course say the book no wo mo.
Ana since the omo ntro no nka say or the application no nya valid.
Omo nka she or should be free beside but omo nka she.
But on tro mo why? Man on tro.
E di be 9 months.
9 months na nka me kwa so. But what the man on tro mo why?
Battery.
Opese you 2 copies so ma wa. Ofra you be 2 copy ama why?
Me battery you ma.
Yo, bye.
Because my brother and so beside.
Okay. All right.
Hello, Uncle Ben.
Hello.
Yeah. And I was in need of more Ghanaian community now.
That's
But a quick question. My junior brother, Oba as a student. But Oba, Oba now didn't can of the buyer.
Bombay is kakra.
Maoni mo yedu.
I'm about to near now didn't buy no. Yeah, Oba no, near now she shouldn't china kwaya copy say Oba be school and sana near no, a baby shano. And the 9% business say Samria near no baby shano. Any car what bought near the of a student no.
That's not I know you have, but now we show you. Say, what the boy when you say,
I'm going to let them and I go school no.
And they're TD what do we read? Only we read Abba, who go school. Me fan is a walk out na campus, and I will read at Tibia Busani be an down for chain. Now, one Shana, say, go you. And I only mean I can't hold you. Why? Okay. All right. But that's it. 02084937345, and that's the number. Young caught line is you. Let's go to the lines again and pick up the next call. Hello. Hello.
Hello. Good evening.
Good evening.
You're ready. Yadama say ne Juma Muya Eddie educate and always.
But can you? Is it possible you could speak in English because of the varied audience we have? But If not,
Okay.
just summarize and I'll put it to lawyer in English because we need to have others understand us as well, if you don't mind.
Okay. Yeah, that's fine with me.
Okay. Good.
Yeah, good evening again. I'm Joe calling from South London.
Yes, Joe.
Yeah, lawyer, I just want to find out, I made an application for my daughter, and initially the application was refused, but we made an appeal, and the appeal, we won the case, so the appeal was, we won the case. But it's been over 3 months now. Up to now, we've not heard anything from Home Office for her to bring her passport for the visa. And I'm wondering, is it normal or is there something that
have
we
you
have
have
to
you
do?
have you written to them? Have you called them to find out why there's a delay? 3 months.
Yes.
When I may, from the experience, at least I've gathered on this program, 3 months may be within their time. But have you really nudged them to find out whether there's anything going on?
Yes, we sent a letter to them, but unfortunately, again, we haven't had anything from them.
Okay.
Yeah, but again, my daughter in Ghana, she's really facing some problems and so on. So I'm really desperate that she come and join me now.
Okay.
So I'm asking, will it add value if I speak with my MP to send a letter on my behalf?
Okay.
Well, I mean, it's always a good idea to consult your local MP. They always add weight to the process. My experience is that sometimes it expedites the application process. Other times it doesn't, but it gives you the reason why it's not being expedited. So it's a good way of getting those who are looking at the application set up. So please speak to your MP.
Okay, thank you.
You're welcome.
All right. 0208-493-7345. 0208-493-7345. Now let's pick a few other comments on the platform. There are people who have sent in text messages and all that. Lawyer, please, I have a child born in the UK who has pre-settled status derived from my mother, child's grandmother, who is an EU national. My settled status application has been refused because I moved from my mom's house. Can a child's father use the child's status to apply for leave outside the rules using direct access and child arrangement order from court? The relevant child has Ghanaian passport, not EU, with pre-settled status. Both parents' names are at school and GP. This child is 9 years.
Yes. It's something that I think we would take a whole hour to do a topic on it. People don't know that if you've got a child here who's got EU limited leave to remain, you can rely on the child. So when the parent route, it starts with a child with 7 years. A child is a British or settled who has indefinite, or the child has limited leave to remain under Appendix EU. In your case, your child has got indefinite leave, so he meets one of the qualifying criteria. If you've got direct access or you have a sole responsibility, you will be able to make an application under Appendix FMELTPT, and the decision will be that 10 years because you don't have leave to remain, but you can switch to 5 years if the other parent is here and they have settlement. If they are not here and they are outside, you can switch to 5 years, yes.
Okay, now the next one says, how soon can I apply for indefinite leave to remain? And secondly, can I divorce my wife from Ghana?
Well, you can divorce anywhere in the world, but you have to go through the court process, because if someone is lived here for more than 12 months, then Section 42 of the Family Law Act of 1996 requires that you use a court process to do the divorce. Yeah.
Okay. 0208-493-7345. Back to the telephone lines. Hello.
Yeah, hello. Good afternoon.
Good afternoon.
Good afternoon, Kweku.
Namayete.
Papa. Thank you for picking up my call.
You're welcome.
This is the same time I've been calling.
Yeah.
Anyway, let me go straight to the point. Uncle Ben, good afternoon.
Good afternoon.
Yeah, I have a quick question. Somebody just sent it to me. She's asking. She came here as a school migrant with a care route, and apparently she's been here for 2 months, being trained by the company, but it looks like the money that she brought or the maintenance that she brought for herself, it's running out, and she has to go back home to get some few funds and then coming back. So she's asking, according to the company, they are okay if she will go, but then she's asking if she's coming back. She goes and then she spends like 2 months gathering some funds to return. On her return, would there be an immigration problem on her way? And if she comes to, would that affect her renewal of her documents in future?
Well, I mean, every person who has limited leave to remain in the UK has a right to go in and out of the UK. Okay. But every person who arrives, including those with indefinite leave to remain, are subject to examination at the border. This is my experience with people on the care visa. When you arrived, very likely that you'll be questioned because they are gathering intelligence. And the intelligence they are gathering are gathered at the port, at arrest center, police center, even with interviews on compliance visit. So why is she worried that if she comes and she's questioned, she might have issues?
Because she's thinking of spending a bit of time, like 2 to 3 months, and to get some funds, because she's not sure just 1 month can get her the necessary money to come back. So
you mean get funds in Ghana?
To gather some funds, money from Ghana.
But she's working here.
No, she hasn't started working yet. She's just on training, so the company hasn't actually paying her fully. So it's like all the means to
Manya, how long has this person been here?
2 months.
And the person who listen, let's be frank, okay? If somebody offers you employment and he says to you that I will pay you £10.75 and I guarantee you £37.50 an hour. If she can't guarantee you the £37.50, she has to guarantee you the £10.75 plus the £37.50. There's nothing like training and paying half. I've seen that with other people who've consulted me. They are not my clients, but they've consulted me. They were going to send that information when they were doing the compliance audit, when they requested for DCUs. And thank God that it came to me. So I corrected it, including the contract that they've signed. Because some of the care contract, they say that we don't guarantee you work. But on your COS, you've guaranteed them 37.50, 38, 40 hours. You've also guaranteed them £10.75 or sometimes even more. Whether they are training, they're waiting for their DBS, whatever. Once they are here, you have to pay them. If you don't pay them, you have a duty. The sponsor has a duty to put it on the SMS. So, Manya, your niece is breaching the law. The sponsor is also breaching the law. If you know the sponsor, tell the sponsor that they are breaching the law. Okay? If you don't want to employ the person, take their name off your SMS, cancel their COS, give them 60 days to go and look for someone. Once the person remains on your contract, you are duty bound to pay them. So, and I hate to say this, if you've not been dismissed by your employer, but they are not paying you, you can sue them. Yes, you can sue them. Okay? And, we need to do things properly. I mean, when this whole thing started, we did warn that typical of our community, there will be greedy and selfish people who will mess it up for every person in this. And that's what is happening. Typical case of what you've called me about. And this is how the Home Office collects intelligence. Your niece will not know that what they're doing is illegal. She will come back. She comes back to the UK. Say, hey, why did you go? So I went to Ghana. For how many months? 3 months. First of all, the employer has to report on the SMS because she's been away for more than 28 days.
That's right.
2, how much do you earn? I earn half of my income. Again, they've gone into the SMS. When you look at the guidance notes for temporary workers, skilled and temporary workers. I think it's paragraph S 4.7 or 4.8. It says reporting duty. If you reduce the income of your employee, you have to report and give us reason why. Somebody who's being paid half of their wages, they are not being paid £10.75. What it means is that both her, which is the niece, and the employer are in breach. Manya, please speak to her. I think she should wait. She shouldn't go. Unless, of course, she wants to forfeit her residence. Okay?
Okay, thank you very much.
You're welcome, my sister.
Yeah, and then the last one, please. If a company is requesting to employ one of somebody's sponsor, and they said they need a letter from the original sponsor to enable them employ this person. So they requested a letter from the current sponsor, but according to the current sponsor, the company just said they've released this employee on their system, so they are not granting any letter. The company should go ahead and employ them. But this new company who really want to employ this person still insisting that they can go ahead straight away until they've received a letter from the current sponsor. And it has been a misunderstanding between these two parties. So I'm asking, is there anything like that, or what they are saying that they've released them and that's it? There's nothing like issuing them a letter to enable them to employ this person.
So Manya, if I understand you, an ex-employee wants a reference. And the employer is not does not want to do it. I mean, it's not compulsory. You cannot force an ex-employer to give you a reference. And if she gives you a bad reference, she needs to justify it. And maybe that's why she doesn't want to give the reference.
Okay.
But for this other company to also insist that they want it from the last employer, I think maybe, they're being a bit pedantic. I think if they get a character reference, that may suffice. Okay?
Okay. Thank you very much.
Thank you very much, and make yourself available. We need you in the studio.
I will.
Your honeymoon is over, so please come over.
Okay.
Thank you very much. Well, that's my co-presenter. Thank you very much, now. My co-presenter now, Mayeti. You will be hearing of her on Friday on the program Legal Hour, and she will be hosting as I'm doing now. And she has her own show, the Mayeti Show, which is in Ga every Sunday afternoon between 2 and 5 p.m. So catch her on YouTube tomorrow afternoon for that. Now let's go to the platform and pick up some comments here. Can you explain the forms of British nationality and how it differs from a normal British citizen?
Well,
is there a difference?
There's no difference. So if there's only one form for naturalization, which is the AN, there's only one form for children's registration, which is the MN1. There's only one form for UKF for children who were born prior to 2006, whose father and mother were not married. So it's a UKF form. The other forms, but for us as a community, the relevant forms are from AN for adults who are naturalizing, from MN1 for children under 18 who are registering, and for UKF for children who are British now or maybe British, but at the time that they were born, their father was not married to the mother. So the law uses the word illegitimate. I'm sorry, but it's now realized that that word was wrong, and they've now brought the British Nationality Act since. So those prior 2006 birth, they've all been brought back and they can get British citizenship.
Okay. Well, let's pick another comment. We have a voice note as well, and I will be looking at that. My cousin came to the UK with visitors visa. She met a man with indefinite leave to remain, and she's pregnant now. When she delivers the baby, can my sister get her documents, or can she regularize her status?
Yes. So this is one of those cases where the parent has nothing. In this case, the mother, but the father has indefinite. And under Section 1.1 of the British Nationality Act, if the child is born because of the father, whether the parents are married or not, the child is British. However, please, if your sister or your cousin came to UK as a visitor, please check with her whether when she completed the forms, she put on it whether she was married or not. Because if she was married and she's not divorced, when she gives birth, although biologically
the child belongs to the other
one in Ghana, and the child will not get British citizenship, automatically the child will have to register and she will have to pay over £1,000 for that.
Okay.
So check that, and if anything, she can file for divorce immediately.
In fact, that law, if I had my own way, they would stop using it.
But we also use that law against them.
Okay.
So we've got instances where someone is married to an EU national who's got indefinite leave. The EU national, for want of a better word, is nowhere to be found. But we know they have indefinite. The Home Office is saying, oh, maybe this marriage is marriage of convenience. This woman has gone ahead and met someone who's as illegal as her, so they've had a child. So this woman, the allegation is that she had a marriage of convenience. A marriage of convenience does not say the marriage is not valid. Under the Marriage Act, that marriage is valid. So if she gives birth, although she's been accused of marriage of convenience, the child is British because the child's father is an EU national with indefinite leave to remain. So we also use it against them. So I think you should stay.
Once you say that, I'll pass any comment. The next one, my marriage certificate is 4th of April 2020. My biometric was done in September 2020. But my application delayed for almost 2 years. My question is, how soon can I apply for indefinite leave to remain?
Well, so when we count 10 years lawful residence, we count it from the very first day they gave to you. If there's been continuous residence means that both under paragraph 39E, which relates to 14 days overstaying, and paragraph section 3C of the 71 Act, you've had continuous residence, bar overstaying for 14 days or less, then 10 years from the date you were given the first one, you get it. So what happens is that you make your application, they grant you, let's say, 2.5 years in 2013. Then you go and renew. From 2013, it expires in 2016, so 2.5 years. And then when you sent it again, they had it for 8 months, and then they gave you 2.5. When you sent it again, it went there for 8 months, they gave you 2.5. So you see that by the time they bring your fourth one, you only have a few months to accumulate the 10 years. You don't have to wait for the biometrics duration. Once you've counted the 10 years from when they first gave it to you, you can put in your application. And in that case, you can even make it 9 years, 11 months.
Okay, all right. Let's see if we can quickly pick this one up.
Good evening, lawyer and Mr. Rico. Pacho, me wa British passport we home and me person me ko family me step sibling or yeah Obama. Me have sibling or Obama, yeah. Me person me ko fan Obaha, like what are the other ways? But he's more than 18 years or 22 years old. Is there any other way, please? Pacho. That's it. Thank you. Bye.
Okay, that's a voice, not uncle.
Yes, she wants to bring her step or her half sibling, and the child is under 12 years, right? Well, it's difficult. First of all, the question is, what status has she got? If she's got a British citizenship or indefinite leave, limited leave, EU nationality, it's all the same, because EU nationality, your sibling will be an extended family member. So the time to bring them is good. But sometimes in very dire situations, if you can prove that a child's presence or absence from the UK may cause untold hardship, there are compassionate circumstances, the Home Office will always look at it. And the law makes provision for you to bring a relative. So a relative is from your siblings to cousins and aunties and parents, dependent relatives. But it can be difficult. I mean, if she calls us, maybe I'll ask her to look at whether adoption is appropriate, although adoption can be very expensive. but also it can be the way for this person to join them. But there are other routes, but we need to do a specific assessment to the individual case to determine whether they qualify.
Well, we have another comment to pick from the platform, then we'll take a break and come back to our quiz. Remember, I gave you the nugget earlier on. We'll be visiting that after this question. Then I'll pose the question and we'll come back to find out what your answers will be. So get ready. What the requirements for EU national with settled status marry in Ghana? What documents does the partner in Ghana need for this application, Uncle Ben?
What is the requirement for an EU national with settled status marrying in Ghana? What documents does a partner in Ghana need? So first of all, there are the mandatory documents. They need to show that a relationship, there is a marital relationship, so marriage certificate. The relationship is genuine, evidence of communication. They need to show that they've met in person. So they've each met. There's evidence of that. The woman is working or has an income of 18,600. If she's not working and doesn't have that income, she has got a savings of 62,000. If she doesn't have that, they may consider GEN 3.1, 6 months pay slips, 6 months bank statement, employer's letter, last P60. Now, your P60 is not what determines whether you earn 18,600. What determines this is your last 6 months pay slip. It's the last 6 months before the month of your application. So if the application is in February, then it will be your pay slip a month before February, which will be in January.
Okay. Well, if you are in doubt of anything, please consult BWF Solicitors 0208 493 7340 0208 493 7340. It's a community in the law, and we have been discussing applying for British citizenship, the good, the bad, and the ugly. And we have also given you the opportunity to ask the senior partner, BWF Solicitors, Uncle Ben, who is our resource person and guest this afternoon, the questions that have been bugging you. Now, we are going to look at what I find very exciting. That segment excites me so much. But before then, let me remind you, do you remember that somebody shared the page so many times and had a reward? What are you waiting for? Share, share, and share. Because at the end of the year, the Senior Partners Appreciation Award could be yours. This person had a weekend to remember. It was lovely. I've spoken to the lady, Tilly. Sorry, I'm telling your story now. I've spoken to Tilly and she enjoyed it. She was over the moon. The fact that she was just helping the community and sharing information and she's being rewarded for that got her so excited that she wants to win it over and over again. You know what? I want you to challenge her. I want you to beat her to the whole thing. Tilly is asking us, saying hello to us. Yes, Tilly, thank you very much for your support and everything. So keep sharing. Pick it up from Facebook, pick it up from YouTube, and also spread it out in your social media network, X, Twitter, that's X, and on TikTok. That's the one I'm looking for. That's very popular now, and everybody's doing their own thing. But listen, use your time appropriately well on social media by sharing information like this, sharing knowledge like this, and that will help you and help the community. Now let's look at my question before I go away and come back. I'm talking about the nugget. I'll start with that. Let me start with the nugget. If you're in the UK and applying to extend your leave to remain, you may apply earlier than 28 days so as to avoid the IHS increase before February 6, 2024. There's no requirement that you apply 28 days before your LTR expires under the immigration rules. However, the guidance says that a period of unexpired leave up to a maximum of 28 days will be added to your leave. If your application is valid and meets all the other requirements when you have more than 28 days left on your LTR. Uncle Ben has variously referred to this RV case, 2012 case from the UK Supreme Court, case number 33. Okay, now let me ask you this question. Nana Weissman is in the UK with limited leave to remain as a parent. His visa will expire on 30th of May 2024. Check the date. We are in February. Okay. Nana wanted to avoid the IHS increase from February 6, 2024, which will add an additional £1,117 to his application and his IHS fees. He wants to apply for his extension by February 5, 2024. He was told by a lawyer that he cannot apply earlier than May 2nd, 2024, that is 28 days before his visa expires. That's a conundrum. Can he not? Can he not? Can Nana apply before February 6 without breaching the law? There are three answers. Choose one. Yes, he can, because there's no requirement that says he cannot apply before 28 days for his visa to expire. 2, no, he cannot, because his application will be refused if he applied earlier than 28 days. Or 3, yes, he can, because it will save him some money before the IHS increases. I think I like that. Anyway, so the next man, I've got the whole world going to help you answer your question. But before then, as they will say, let me make some money and I'll be back.
Our private client services team is recognized for providing clear and practical legal advice to our clients in the United Kingdom and Ghana. Expert help with will writing, probate or estate administration. Our will writers and probate lawyers can act for you to obtain grant of probate and carry out estate administration on your behalf. The probate takes place after someone dies. If there's a will, the named executor is responsible for ensuring that the estate of the deceased is secured, assessing its value and paying any inheritance tax. If there is no will, the intestate and inheritance rules require similar responsibilities. Our lawyers offer strategic and practical solutions to the issues which clients face, whether it's in relation to succession planning, will preparation, probate and the administration of estates, immigration and visas, contentious family or probate disputes, administering estates often with inheritance cross-border issues, international trust advice including residence, domicile issues, wealth preservation, a fast, efficient service from SRA-regulated professionals, transparent pricing. BWF Solicitors. Let us take care of probate.
Okay, yes, I've made my money, I'm back. Making my money is just to say thank you to BWF Solicitors. We need to appreciate this organization. For over 30 years, the senior partner has really worked to help the community, empowering us with information and knowledge, and also making sure that we stay on the right-hand side of the law. So BWF Solicitors, I salute you and I thank you very much, and I encourage you to keep doing what you are doing. People, call BWF Solicitors on 0208 493 7340 or 077 127 61884. Okay, Nana Weissman is in the UK, and Nana Weissman has a conundrum. He wants to apply before the 6th of February 2024. Meanwhile, his visa will expire on the 30th of May 2024. Now, there is a lawyer that has advised Nana Weissman to say that, nah, don't do it. You can't do it before 28 days. 28 days before your visa expires. So don't try. You'll be breaching the law. Don't worry. Forget it. Go find some money. Go and pay 1,117 in addition to all those things. That's a lot of money. Okay, so now let's help Nana. Can he apply? Yes, he can, because there's no requirement that says he cannot apply before 28 days for his visa. Well, another person is also saying, no, he cannot, because his application will be refused, and if he does apply earlier than 28 days, so he will be in trouble, he'll be breaching the law. Now, another person says, oh, yes, yeah, he can. Go on, apply, because it will save you some money before the IHS increases. Which one is the correct answer? Let's see what people have. Sarah Indede, sorry for butchering your name. Sarah Indede. It says number 1. Yes, he can, because there's no requirement that says he cannot apply before 28 days for his visa to expire. Ademununkum says number 3. Yeah, it seems to resonate with me as well. Yes, obviously, I'm going to save 1,117. So yes, he can, because it will save him some money before the IHS increase. Amma Diana 1 and 3. I like that. You're making it convenient for yourself, isn't it? Well, Amadina says 1 year and 3 years. Yes, there's no requirement, and it can save him money as well. So Amma thinks is 1 and 3. Okay, let's see what another person has. Well, somebody's brought in a question, but unfortunately, let me finish with my quiz. If I have a few more minutes before we draw the curtains down, I may consider that. Other than that, I will put it in the fridge and we'll come back to it next week. Tilly Duma, Tilly, how are you? He says number 3. Okay, let's see. Is there any other person bringing any other answer before I go over to get the correct answer? Nana Weissman in the UK with limited leave to remain as a parent has a visa that expires on the 30th of May 2024. He wants to avoid the IHS increase, which is coming on the 6th of February 2024. And if he is not able to make the application before that, there is an additional £1,117 that will be added to the application and the IHS fee. He wants to do that before the deadline, so he wants to do that by the 5th of February 2024, which is Monday. Now, a lawyer says that, oh no, you can't do that. You have to apply on the 2nd of May, which is 28 days before your visa expires. But the lawyer says, well, I've been hearing things, so please help me decide. Can he do that? Yes, because there's no requirement that says he cannot apply 20. But another person also says, no, you can't, because his application, your application will be refused if you apply 28 days earlier. Then another person, oh, listen, save money. Apply it. Yeah, apply for it. Go for it. Save money, because 1,117 is a lot of money. What is the answer, Uncle Ben?
Okay, so first of all, the reason why this question was asked is to help people practicalize the nugget. The nugget itself is pointing to the fact that we are urging the community members, those whose leave may expire after the 6th of February, to put in the application early. They have 35 days, not 40 days, 35 days to attend their biometric. So in this case, Nana obviously has a conundrum. If he waits till the 2nd of February, May, he would have had to pay the extra 1,117. But we say that he can put in his application early. So he can make the application on the 5th of February. He will enroll his biometric on 35 days. That will take him, if you add that, that will be 41 days. That will take him to about April. Once he's enrolled, he's within the time. His leave obviously will be protected under Section 3C if it expires at the Home Office. But above all, he would have saved £1,117. There's no law which says that he can apply only 28 days to the expiration of his leave to remain. The guidance notes clearly gives advice, but the law does not say that. So even if the application is considered before the 30th of May, his leftover leave or his extinct leave will be added up to 28 days on his leave. It doesn't really affect anything, but he will save 1,117. And if it's a family of 2, 3, or 4, they will save multiple 1,117. So the answer is 1.
Well, I've got some who were trying to be smart. I think the last person. Evidently, there will be some saving of 1,100.
That's correct, yes.
But well, technically the answer is 1 because that's what the law says. Where an applicant currently has extended leave to enter or remain as under Appendix FM at the date of application, that period of extended leave up to a maximum of 28 days will be added to the period of leave to remain that they are being granted as it is published for Home Office staff on the 15th of May 2023 based on Alvi, a case of 2012 UK Supreme Court ruling. Well, so listen, do that quickly now, between now and Monday. Ooh. Let's BWF Solicitors be extra busy on Monday, I'm telling you, so that we can beat the deadline together. But before we go on, let me pick some of the updates that have come quickly. I want to remind you so that you will be on point. Apart from the nugget, healthcare sponsors can no longer sponsor migrants unless they have CQC. The Minister for Legal Migration and Border has announced that from March 11, 2024, care sponsors can no longer sponsor migrants unless they are CQC registered. That is Care Quality Commission registration. It is not an examination. Don't think of it that way. The minimum income threshold for skilled workers is raised from 26,200 to 38,700. This has been announced, and that starts from the 4th of April 2024. And it says that the earnings threshold for those on the skilled worker route would increase from 26,200 to 38,700. The health and care visa route is exempt from this change, as are workers in national pay scale occupations. Now, the next one, probably the last one before I go back to Uncle Ben for our summary, will be about household, that is the 18,600. The minimum income threshold for families will be raised from 18,600 to 29,000, and in due course it will be raised to 34,300, and then eventually to the 38,700. Thank you all for paying attention. But let me go over to Uncle Ben. So, as our tradition on this program is, you give us a brief summary as to what the good, the bad, and the ugly of applying for British citizenship are.
So thank you all for joining us today. We're very grateful. The brief summary of today's presentation is that British citizenship is not a right, it's a privilege, and the requirement for people to be granted British citizenship is for them to respect the UK law, including paying their taxes, not breaching their council tax payment, paying their debt, not being bankrupt, not having criminal conviction, and making sure that they also meet the residential requirement. For those people who are married to British citizenship, it's 90 days absence, up to 90 days absence a year. So for 3 years, it's 270, although you can do up to 490 in certain instances. For those who are applying in their own right under Section 6(1) of the British Nationality Act, it's 450 over the 5-year period absence. It can go up to 900 days of absence. However, you need to justify that. So for us, as a law firm, our advice is basically to comply with the British laws, respect the British laws, make sure that you don't claim benefit if you're not entitled to it. Make sure that if you've used the NHS and you've been billed, that you paid the NHS fees before you apply for British nationality. And the reason why you may be billed for NHS payment is if you do not have lawful residence in the UK. So, ladies and gentlemen, again, thank you. Let's comply with the law if you want to become a British citizen. Thank you.
Need I say more? The senior partner himself has summarized for us, and I would want to say that if you need any further explanation, please visit BWF Solicitors, as we find the numbers at the bottom of your screen, 0208 493 7340. The Ghana number for the Ghana office is 05559 5959 055-589-5959. And for emergency situations, call BWF Solicitors on 077-127-61884. It's been another wonderful edition of the Community and the Law, which is brought to you by BWF Solicitors right on BWTV, also live on Facebook and YouTube on BWF Solicitors pages. We have, as I said, mentioned and discussed and repeated over and again, the application for British citizenship. We have the good, the bad, and the ugly, and Uncle Ben has rightfully summarized that. We want to congratulate, I think we didn't have that, but we want to congratulate Lawyer Charles Asma for being the employee of the month of January. We celebrate that. Thank you very much, and keep doing what you're doing. We love you to bits. And to the family of BWF Solicitors, led by Auntie Cynthia, and all our trainee lawyers, the admin and case workers and support workers, and the lawyers, particularly Uncle Ben, the senior partner. I want to say thank you very much for your support, the advice, and the encouragement you give us here on the program. To my studio producer, Professor Adair, to Sheila Ankra, my admin, and of course, Padmo Dudu, the aesthetics and design person, I want to say thank you so very much for being here with us on another edition of the Community and the Law. And we promise you, same time next week, we'll be right back with you on the same platforms that we have. Keep sharing the pages. You could be rewarded for that. And of course, remind people that we'll be back again. My name is Ulrike Usufrimpo. Have a good evening.